This educational video is brought to you by the Colorado HOA Information and Resource Center. The topic of this video presentation pertains to the maintenance of the common interest community and its insurance obligations. The information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Maintenance of the common interest community is set forth in the Colorado Common Interest Ownership Act, also known as Kiowa, in Section 3833.3.307 of the Colorado Revised Statutes. This section discusses the maintenance, repair, and replacement requirements for the association and its owners. Who is responsible, the association or the homeowner? Under the Kiowa law, unless there is a statement to the contrary in the declaration, the association is responsible for the maintenance, repair, and replacement of the common elements of the association, which includes both the general and limited common elements. And it is the owner's responsibility for the maintenance, repair, and replacement of such owner's unit. Additionally, each unit owner shall provide the association or their agents and employees access through such owner's unit reasonably necessary for those purposes. This access would be typical in condominium communities. If damage is inflicted on the common elements or any unit through which access is taken, the unit owner responsible for the damage, or if the association is responsible, would be liable for the cost of the repair. Generally, a homeowner is responsible for maintaining anything within their home unit. However, as board members, it is extremely important to review the declarations and covenants for guidance and a determination of who has the responsibility for maintaining the many items in the community, the HOA or the individual homeowners. Maintenance issues for a homeowner is much different in a single-family development versus a condominium community. Maintenance and responsibility schedules. It is an advantage to your association and its homeowners to develop and distribute a maintenance and responsibility schedule so homeowners know what they are responsible for and what the association is obligated to maintain. A maintenance responsibility chart should be developed and used as a very practical, clear, and preemptive roadmap of maintenance responsibilities. An association can get assistance creating this list by working with their legal counsel and insurance agent. An added benefit of having this chart available is that it will help the board make better decisions for the association and avoid unnecessary requests for repairs that are not the responsibility of the association. If there are maintenance, repair, or replacement of any drainage structure or facilities or other public improvements required by the local governmental entity as a condition of development of the common interest community, that shall be the responsibility of the association, unless such improvements have been dedicated to and accepted by the local government entity. Declarant maintenance concerns. The declarant is the developer of the subdivision, and the association was created for its benefit. In some instances, the declarant may still be in control of the homeowners association. In that case, the declarant alone is liable for all expenses in connection with real estate within the common interest community, subject to development rights. No other unit owner and no other portion of the common interest community is subject to a claim for payment of those expenses. Unless the declaration provides otherwise, any income or proceeds from real estate subject to development rights inures to the declarant. If the declarant fails to pay all expenses in connection with the real estate within the common interest community subject to those rights, the association may pay the expenses, and such expenses shall be assessed as a common expense against the real estate subject to the development rights. Insurance of the association. In the Kiowa law, homeowner associations have an obligation to provide insurance. There is both mandatory and optional insurance coverage. Premiums for insurance that the association acquires and other expenses connected with acquiring such insurance are common expenses. Section 3833.3.313 of the Kiowa law covers insurance obligations of the association. The association shall maintain, to the extent reasonably available, property insurance on the common elements, and in a planned community also on property that must become common elements for broad form covered causes of loss. The total amount of insurance must not be less than the full insurable replacement costs of the insured property less any applicable deductibles. The association shall also maintain commercial general liability insurance against claims and liabilities arising in connection with the ownership, existence, use, or management of the common elements, in an amount not less than specified by the common interest community instruments, ensuring the board, the owners association, the management agent, and the respective employees and agents. The unit owners shall also be included as additional insureds for certain claims. If these insurance coverages are not reasonably available, or if any policy of insurance is canceled or not renewed without a replacement policy having been obtained, the association shall promptly cause notice of that fact to the owners. In addition, the association's declaration may require it to carry any other insurance, and the association may carry any other insurance it considers appropriate. The insurance policies must provide certain terms under law that have to do with owner's liability, subrogation of claims, voidance of a policy, and issues of primary insurance coverage. These are complicated insurance issues and should be reviewed and discussed with your insurance agent and legal counsel. Certificates of insurance. An insurer that has issued an insurance policy shall issue certificates of insurance to the association and, upon request, to any unit owner or holder of a security interest. The association should adopt certain policies regarding insurance coverage. Regarding policies for insurance for the association may adopt and establish written and non-discriminatory policies and procedures for the association. Those association-adopted policies should be related to the submittal of claims, the responsibility for deductibles, and any other matters of claims adjustment. To the extent the association settles claims for damages to real property, it shall have the authority to assess negligent unit owners causing such loss or benefiting from such repair or restoration all deductibles paid by the association. In the event that more than one unit is damaged by a loss, the association, in its reasonable discretion, may assess each unit owner a pro rata share of any deductible paid by the association. Insurance proceeds for damage to the association. Any portion of the common interest community for which insurance is required that is damaged or destroyed must be repaired or replaced promptly by the association, except under limited circumstances. The cost of repair or replacement in excess of insurance proceeds and reserves is a common expense. Homeowners insurance policies. An insurance policy issued to the association does not eliminate the need for unit owners to obtain insurance for their own benefit. Owners should have their own policy of insurance, and it should tie to what the HOA's master insurance policy covers versus the homeowner's personal policy. There should be coordination. Also, there are different homeowner insurance policies depending on the type of home unit. Single-family home policies, HOI policies, versus condo units, HO6 policies, that are designed specifically for condo owners. Fidelity insurance coverage. What is it? Fidelity insurance coverage protects the money the association has in the operating account and reserve accounts, and protects the money from embezzlement, check fraud, invoice padding or false invoices, computer fraud, and wire fraud. In the Kiowa law, if any unit owner or employee of an HOA with 30 or more units controls or disperses funds of the HOA must obtain and maintain, to the extent reasonably available, Fidelity insurance coverage. Coverage shall not be less than 2 months' current assessments plus reserves as calculated from the current budget. The HOA may carry Fidelity insurance in amounts greater than required. Any person employed as an independent contractor by an HOA with 30 or more units for the purposes of managing the HOA must obtain and maintain Fidelity insurance coverage in an amount not less than 2 months' current assessments plus reserves as calculated from the current budget, unless the HOA names a person as an insured in their contract of insurance. The HOA may require that contractor to carry more Fidelity insurance than required. This has been an educational presentation from the HOA Information and Resource Center. Following this presentation, you will find a short quiz and some HOA resources. Thank you for watching.